Oh, hey, thanks. Okay, I'll watch what I say now since we're moving. Okay, this is going to be a mild version of the presentation. It's going to be mind-blowing, but I just don't want to be recorded saying anything too offensive. Just, just kidding. But thanks, Catherine. That was an exhaustive bio, and I feel like I need a nap now. But mainly, I'm Justin, and I'm a supporter of the arts, and happen to be an attorney. And it's wonderful to be here with you this morning. Quick side note, if you have questions along the way, please feel free to ask. It's always fun for these to be a dialogue more so than a monologue. So yeah, just when appropriate, just turn on your screen and say hello. Intellectual property is typically referring to three primary pillars. I'm going to pull up a slide here just to guide us a bit, but I'll try not to keep it up too long so we can see each other. Where did it go? See if I can find it. Okay, should be on the screen. What's this? Can you all see? What do you see right now? You see it says intellectual property. Okay, cool. Yeah. Okay. Well, so the first part of the holy trinity of intellectual property is patent. The second is copyright. The third is trademark. I'm not a patent attorney. A patent is a specialized area. You have to have a hard science background. And so my knowledge of patent is limited, so our time on it today will be limited as well. But I want everyone to have a working knowledge of patent. The patents protect inventions. It also can protect designs, packaging, the Apple Store building. If you are an inventor and you feel that you've in your garage made this revolutionary device, something that's novel, non-obvious, useful, that's going to revolutionize the world, my recommendation to you would be to immediately pause and chat with a patent attorney. My go-to patent attorney in Richmond recently joined a mega firm in Atlanta. So there's a new one I recommend, and I don't know him well, but his name is Stephen Keefe, Keefe, and that's keefeip.com, keefeip.com, and Stephen can answer your patent questions. Something to note is in order to have patent protection, it must be bestowed upon you by the federal government. So when we discuss trademark law and copyright law is where I spend a significant portion of my day, we'll learn that that's not necessarily the case. But with respect to inventions and patent protectable devices, you have no rights unless the government gives them to you. And also, too, if you jump the gun and you start using your device and sharing it publicly, you can spoil your ability to protect your rights. So it's important early in that process when you've created your widget to speak with someone and decide where you want to take it and where you need to go. There is a type of application called a provisional patent, which gives you a 1 year runway to share and use it to bring on board investors. And that's what folks with startup companies, think Silicon Valley, and actually probably a lot of people who had their money in Silicon Valley Bank have patents, right? So, but luckily or not, maybe the government's going to bail them out. So we'll see what happens there. But 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 just for this purposes of this conversation and my limited patent knowledge, just to understand that if you've invented something, before you get too far down that path, speak with a patent attorney, understand you have no rights unless the government grants you a patent. And also what's interesting about a patent is it's a negative right. A patent doesn't give you the right to do anything. It gives you the right to tell someone else not to do something. So that's patent. Now, here's where we're going to spend a lot of our time, and that's copyright and trademark. I'm going to go ahead and close this presentation here because I don't know if the slides are too helpful, but just so you can take a second look at it. You can take a screenshot if you want to refer to patent or to copyright, and then here's the trademark. But let me stop this. So let's begin with trademark. Because I see a trademark on the screen, I see Coke, right? Share a Coke. So trademarks. A trademark is a designator of source of a product or service. So let's have some conversation. So beyond what's on the screen, does anyone want to share a trademark they've interacted with today? What's a brand that you're interacting with? Actually, we're all interacting with a brand right now.
Zoom, Apple.
Yeah, there you go. Zoom, Apple. Um, and I tell you, I mean, brands work, right? So Zoom, we're Zooming right now. And early on, I had limited engagement with Zoom prior to 2020, but I tell you, if someone says we're going to Zoom, we're going to was it like Google Meet or like Office Teams? I overall have had good experiences with Zoom. Zoom typically works. I click the button, I'm on, I chat with people. In my day-to-day practice, whenever an attorney or a client or someone else says, hey, I sent you a link for an Office Teams meeting, I my initial reaction is, oh, this is going to be a pain. I'm going to like my software is going to have to update. I'm not going to be able to see them. I'm going to maybe get into the meeting 10 minutes late if I'm lucky. And who knows, it's like a 50-50 chance. And that's this is how trademark works, right? So trademark in this instance, Zoom, it's a word, right? And through our use of the service, right, software as a service, now I have an impression, right? There's a goodwill, there's a value to it, right? As to do I like Zoom? I think the answer is yes. Out of the options, I like Zoom. When it comes to Teams, my experience hasn't been as good, so I typically don't choose that. It's the same thing. Pepsi and Coke products, right? Have you ever gone somewhere and you ask for a Dr. Pepper and they tell you we've got Mr. Pibb, and you're like, oh man, Mr. Pibb. Oh, what am I going to do with this Mr. Pibb, right? So people make choices, and where they make decisions as to which product they prefer, and then it's the trademark that tells us how to get it. So if I'm in Spain and let's say I'm tired of little bitty coffees, I'm like, man, it's espresso. I need a big old glass of American coffee, like a beacon in the sky summoning me. I see this mermaid image, right? What have I seen? Like what am I heading towards? What's my northern star here? If you want American. Yes, exactly. Thanks, Piper. Yeah, Starbucks. So I know, I'm like, okay, cool. That that image. And so thinking about devices, like what can act as a trademark, what can act as a designator of source. It could be a word, Zoom. It could be a word, Starbucks. It could be an image, like the Starbucks mermaid. Also, to think shoes. What's a famous shoe logo design? So you want to take a shot there? Like, what's something if you see on the side of a shoe, you know what it is?
The Nike mark.
Exactly. Yeah. Thank you. Yeah, the Nike swoosh. Right. So it could be an image. Sometimes they're coupled together. So going back to the Starbucks example, for years it was the mermaid or siren image, and it said Starbucks underneath. Then over time they took away the word Starbucks because people had a brand association with the logo, that image, and so they didn't need the words anymore, and that's a really strong brand. Just so you all know, there also can be beyond a word or a image, there are other devices that could be designated of sources. Think about like television, sound, right? Have you ever been on? Have you ever watched NBC? there's a tritone. You know what I'm talking about? You hear those? I won't sing it for you. If someone wants to sing it, you can. Um, but I bet you if we sang that tritone right now, you'd think NBC. Also, and that's a registered brand, I believe. I don't know if this one's registered, but have you ever watched Law and Order? Like the don't, I'll do that one. But you hear that knocking sound, and you know, like I'm watching Law and Order. Same idea. Or Netflix, right? There's that tone that, and you could be, you could be in another room and you hear it, and it's like, oh, someone's watching Netflix, right? You know, and that's because that tonal pattern is used in a way that designates the source of a brand. Also, colors. Can anyone think of a famous color in jewelry? What's a color you see and you know you're
Tiffany
in
blue.
exactly. Yeah, you got it. Thank you. That's not to be confused with Richard Petty blue, which is famous NASCAR color trademark. Also, pink insulation, Pink Panther, right? Um, and then also in the trademark world, smells, scents, right? Like Kim Kardashian has a trademark for her scent. Probably not her personal scent, but the scent that they made for this perfume. Um, and so just want everyone to have to realize that a trademark is a designator of source of good or service. We refer to them as brands, and it most often it's a word or a series of words, right? I'm loving it. McDonald's, just do it. There are these famous taglines. Or it could be an image, it could be sounds, it could be a color. It's just so long as when a consumer interacts with it, they know that a good or service coming from somewhere, that's a brand. Now, trademark rights in the United States, unlike patent, right? Unlike patent, the government does not have to bestow upon you trademark rights. There are common law trademark rights, right? And I guess bestow upon you, I mean, you do not have to apply and register to have rights. By using a trademark in commerce in the US, this isn't the case in other uh, geographic locations, jurisdictions in the world, but in the US, as you begin to use a brand in commerce, your rights begin to vest because consumers are interacting with your brand and they get to know you, get to know your products, so you have rights. So if you've opened up your shop, or if you're a musician, you're an artist, and you're out there and you're creating, and your trademark, your brand is on your product, you have rights simply by using it. Now, something to note: before you adopt a brand, it's good to see if anyone else there's beat you to it, right? Because you don't want to step on someone else's toes, because they could tell you to stop, right? Stop using it. Also, too, there are benefits of registering your trademark, your brand. In a world without registrations, your rights are limited to where you're known. So think about it. So this band, so with this band, Clutch, and Clutch, they're musicians and they tour around, and Clutch has a federal registration, but let's say Clutch didn't. So if Clutch didn't have a registration and they primarily played the Mid-Atlantic region, so let's say folks knew them in Virginia, North Carolina, Maryland, DC, that area. If someone tried to create a band called Clutch, what would happen is, at least where they're known, if someone said, "Hey, I'm going to call my band Clutch," or let's say they wanted to call it Clutches, right? Just add an ES. It doesn't have to be exactly the same. And this is something that's important to note: is if you're choosing a brand, if you know someone else there is already using something, and you're like, "Well, I'll just change the spelling of it. I'm going to call it corn with a K or corn with the C because the K is taken." Um, Now, if you decide to call your band Corn, that says something about you. And I'm not sure that's a good thing or not. But and that's a joke if you like corn. But if you want to call your band Corn with a C and you said, "Oh, it's okay, they're Corn with a K, I'm Corn with a C," that's not the case. The question is whether or not a reasonable consumer would be confused, right? Confused as to the source or confused as to a association or an endorsement. So let's say that I'm about to open up my coffee shop, and I said, you know what? Uh, I'm gonna I'm gonna call my coffee shop Stirburks, Stirbercks. Or actually, here's even a better one, right? This is really funny. I'm gonna call my hamburger shop McDowell's, and we're gonna have the golden arcs, right? And we're gonna have the Big Mick, not the Big Mac. That is just that's the reason why Coming to America, why it's such a funny joke, is because everyone sort of knows, right? This is embarrassingly trademark infringement, because the idea is, would a reasonable person, a reasonable consumer, an average reasonable like third party consumer, if they happen to find this place, would they think either it's coming from the same source or they're somehow affiliated or endorsed by it? So if I created my coffee shop and I wanted to call it Stirburks instead of the Mermaid Siren, I had Neptune on there, and we specialized in tea, not coffee. Starbucks probably would have a legitimate claim against me, tell me to stop, because even though it's not identical, it's so closely related to it that um, that it could cause confusion. Someone would think either this is, maybe someone might think it is Starbucks, or someone would just think it's um, endorsed by or affiliated with it. So, for our purposes, if you're about to choose a brand, make sure that you've done your due diligence and Google searching um, at uspto.gov. You can go to type in here uspto.gov. There is a search portal called TESS. It's a trademark electronic search system, and you can search brands, and you search based on similarity. And the similarity question is, it's the good, like what are the goods and services, and what is the mark, right? The closer the mark, the less close the goods have to be confusing. The closer the goods, the less close the mark has to be confusing. And then if you have a scenario where the mark itself is close and the goods are close, now you're really about to cross and have some confusion. So an example of this is Delta Airlines, Delta Dental, Delta Faucet Company, right? The idea being that if I'm on a Delta flight and I go brush my teeth in the laboratory, I wouldn't say, well, hot damn, they're flying the plane, they built the faucet, and they gave me the insurance, they got me this toothbrush, right? A reasonable consumer, a person wouldn't think that those are all connected because the goods and services are so far apart. Same idea with our law firm. We're Threshold Counsel. We provide legal services. If you go to Target, you can buy an assortment of hand towels, bath towels, bath mats, rugs, different home goods that are all branded Threshold. And that's okay, because a reasonable consumer is not likely to confuse the law firm with the bath mat company. Okay. Now, something to note, famous brands, just like famous people, have more protection than the average person or average brand. So in the world of fame, there is a concept known as dilution. So if you said, hey, I'm going to call my accounting firm Pepsi Accounting, it's probably not going to fly, not because someone's going to confuse your accounting firm with PepsiCo, the cola company, but because Pepsi has reached a certain stature and would be deemed a famous brand. There is a concept known as dilution, in your use of the brand, even if used on a separate product, you're diluting that brand. So, and typically the rule of thumb is how do you determine something's a famous brand? And you determine that by if, well, once again, if an average person would know the brand. So, Amazon, Pepsi, um, Apple, right? Any of these brands. And that's called a 2D likelihood. Um, what I've been discussing is 2D likelihood of confusion. Is your brand likely to cause confusion with another brand? And then you have to ask who was first, what was first. Okay. And so once again, trademark is a designator of source. It could be a word, it could be an image. When you begin to use it in the marketplace, you have common law rights. You don't have to have a registration for that. Without a registration, though, oh yeah, good point about Apple door systems versus Apple. Um, you have to. It'd be interesting to see why Apple hasn't pushed on Apple door systems, or if maybe they don't care, or when Apple door systems was created. Now, something to note is a brand could still be famous, and there could be other brands out there, but it could be a moment in time as to when they slipped in. It could be that Apple didn't care enough to enforce. So I would argue that, and I'd have to pull up the legal test as to what is or is not Apple. Apple records predated Apple Apple computers, and there actually is a consent coexistence agreement there. When Apple, the computer company, ended up using it and moving into music with iTunes, there was a consent agreement there. So I wouldn't, yeah. So I would probably, I would argue that Apple would meet the famous tests. There, once again, there could be specific instances where they haven't enforced or don't care. Also, too, there could be a question if Apple hasn't, if they entered a crowded field, then their rights could be diminished. For purposes of the Zoom, though, I would say, generally speaking, if you know the brand, I probably would stay away from it. But I mean, you can always go for it and see if they care. The question is, as a business owner or as someone trying to build, do you want to step in a mud puddle, right? Because people can argue over things, and the argument itself, even if you end up winning, is going to take time and cost money. So now we have some clients that they they maybe would relish in the opportunity of a fight because they think it would bring awareness to them, and maybe they get some publicity out of it. But that is not what I advise anyone to do, because publicity is one thing, paying significant amount and damages for infringement is another. So I would consult with an attorney and then decide where your risk tolerance is. But yeah, that's a great point, and about Apple. But back to where we were. When you adopt a brand, first piece, do some due diligence, see what else is out there. And attorneys can help. There's third-party search companies that will help search the brands, and then you can get a pre-clearance to help you to see exactly, what you're entering into. Once you know the brand is hopefully available or clean enough where you feel comfortable moving forward, although you could rely on common law rights, your rights are only where you are unless you register them, which means that if you're only in Central Virginia, then if you later try to offer a product in Omaha, Nebraska, you might or might not be able to, because if you don't have rights there, someone else could use the exact same brand and they have rights there. And so you have pockets, right? Like you're blah, blah, blah here, they're blah, blah, blah there. And no one has rights across the US because it's just been used so often in common law that no one can be the one owner of it. So what you do to allow you the ability to expand is you would move forward with the federal application. Now, in order to register your brand federally, it has to be in use in interstate commerce, right? It has to be used in such a way that it's governed by federal law. And so, depending on what you are offering and what you're selling, you might immediately have use in interstate commerce, or you might have to wait until you cross state lines. So, yeah. So, do you need an attorney to file a trademark application? You do not need an attorney to file it. You can go to uspto.gov. The federal government, much to chagrin.
Who have not been marked.
Um, so, the federal government has done a fairly good job of providing information at uspto.gov, United States Patent Trademark Office, so uspto.gov, to lead you through the process. There's really sort of three choices you have. One is self-help, go there and file it. The second would be to hire an attorney. The third would be to go to LegalZoom or any of those providers. The third option, LegalZoom, is a little bit iffy, just because in my experience, what LegalZoom is they basically take all the questions the government would ask you, and then they put it in a easier form. And it seems less daunting because you're interacting with LegalZoom, not the government. And then essentially you tell LegalZoom what you want, and then they do exactly what you would have done directly yourself, but you pay them a fee to do that. And there's a way to pay more to speak with an attorney via LegalZoom. But over the years, LegalZoom has generated a decent amount of work for me, because what happens is someone files themselves and they don't really know what they're doing, and LegalZoom doesn't really tell them that they're not doing it right. And so what happens is they file via LegalZoom, and then it's called an office action, and so then they've got to interact, they've got to fix something, and so then they hire an attorney. So yeah, I don't know the folks on the Zoom, your ability and comfort filing, but the short answer is you can do it yourself. Just depends on your level of comfort, and also too sort of your understanding. So for example, this interstate commerce question, when you file the application, you sign an affidavit, and you have to give the basis of filing. One is intent to use. You intend to use it in interstate commerce, but you're not yet. And what happens is if you file that, eventually you'll, if it's successful, it goes to the gauntlet, the process, then you receive what's called a notice of allowance. I'm shaking the screen. The government has notified you that they will allow the mark to register once you put it to use in interstate commerce, and you file an acceptable specimen and amendment to allege use. So basically you say, hey, when I filed this, I wasn't using it in interstate commerce, but now I am. So I'm starting an apparel company. I'm going to start selling t-shirts. And Lauder brand, right? Lauder brand shirts. And let's say I'm selling some shirts, but I'm only selling them in Virginia. And because I'm an attorney, and well, not because I'm an attorney, but because I'm a trademark attorney and someone who understands this area of the law, I know that if I'm only distributing my shirts in Virginia, that's not interstate commerce. And so when I fill that application out, I'll file an intent to use based application, because even though I've been selling in Virginia, I have not crossed state lines yet with my product. And I'm not offering it online. I don't have a website, or I'm not shipping across state lines. And so I file intent to use. Now, sometimes what will happen if someone doesn't understand the nuances of the law, if they file themselves, they might think interstate commerce, yeah, I'm selling shirts. And so they'll file use-based, they'll sign an affidavit, a declaration with the government saying that as of March 15th, 2023, I'm selling these in interstate commerce. The government's going to take your word for it. And then later, what could happen is if you were successful and you received your registration, if someone later said, well, we questioned this registration, Lauder brand. They could push on it, and if it then was discovered that in fact I'd only been selling in Virginia and not in interstate commerce, then that would be an issue for me. Likely they could, if I weren't an attorney, didn't know anything, they probably wouldn't throw me, say I committed fraud on the federal government because it was unintentional and it's just more of a lack of knowledge, not willful misconduct. But because I wasn't actually using it, the application and the registration would fall. So yeah, I certainly can file directly, but make sure you do your due diligence and read on the site and understand your comfort level. Also, things that you just kind of learn in practice. So like right now, I'm I'm wearing 2 GWAR shirts. So GWAR is a heavy metal band that I work with. And so I've got one on here, like this is just like a GWAR shirt, right? And so if GWAR filed to protect in class 25 for apparel, and you'd list, you file in these codes. And so these filed for t-shirts. And I submitted a picture of this. Well, this use of GWAR is not a trademark use. Putting a brand on the front of a shirt or an image, that's called ornamental. Because if you look at this shirt, if you look in the tag of this shirt here probably says American Apparel, right? It's an American Apparel branded shirt, which just happens to have an image on it. So to have use in apparel, and this is something that people do all the time wrong. And I've seen lots of legal Zoom filings of this incorrectly. They'll file a bunch of specimens of a ornamental use and it'll be rejected as ornamental. Where really, in order for it to be an apparel brand, that has to be on the shirt tag, right? Or the hang tag, or the bag has the apparel. So this other shirt I have on, let me see. Sorry, I'm not trying to strip for you guys right here, but let's see. This one, I think, would work. Yeah, I see. This is a Dixon flannel shirt, but you see GWAR is now in the actual shirt tag. And so this is a co-branded shirt. And because of that, and also too, there's a GWAR on the that says GWAR on there too. And so as that image, that word is on the actual product as a brand, then that qualifies it for use as a trademark. So yeah, certainly uspto.gov is a great place to learn more about trademarks and potentially file yourself. And then there's always professionals you can use. Now, I know we need to switch over to copyright, but one last thing, just for everyone to know, is on the trademark side is when choosing your brand, there is a range of protectability. Fanciful brands are the most protectable. So a fanciful term is something you just make up, right? A word that didn't exist and you just create it. So we'll use GWAR. GWAR is a made up term. That's the strongest brand, just something you made up. The second strongest is arbitrary use of a word. So we'll go back to the example of Apple. Apple for a computer company, that's arbitrary, right? That's fine. Or Amazon has nothing to do with the Amazon, right? It's an online marketplace. That's arbitrary use, and that's a strong brand. So you've got fanciful is the strongest, arbitrary, then suggestive. Suggestive brands, suggestive terms are protectable trademarks. They don't describe something, but they're suggestive. So Tinder, for example, that's a suggestive brand, right? It's a few steps removed. It's like, oh, Tinder, I get it. You're supposed to, it's about romance and love, and maybe not love, but love can come out of Tinder. But yeah, it's about this idea. Okay, it's a flame, right? Tinder, and it's suggestive as to what the product or service is, but doesn't describe it. And then you get into descriptive things, right? So, if you tried to like surnames in products, that's descriptive. So Lauder's Law, Lauder Law, my last name plus law, right? That's descriptive because it describes like, hey, this person and I do law, right? That's descriptive. And so descriptive brands are not automatically, Descriptive brands can be registered on the supplemental register for some protection, but they don't give you the same strength as the principal register. And then and over time, it can acquire distinctiveness, be more protectable, but try to stay away from descriptive brands. And then generic can never be protected. So if something's generic, law firm, that's just generic. Because the idea is that you can't tell someone they can't describe what they do. So anyway, I know we spent a lot of time on trademark, and there's so much more to unpack, right? It's funny, I've given hour-plus presentations just on trademark. But before we switch to copyright, any questions on? Actually, I'm going to read the questions on the side, but any others? So yeah, so you can trademark the image logo. So that'd be the Nike swoosh, the mermaid. Trying to think, the apple, right? The apple image. And also, that's a great question, because note that we started with this. What are the three primary areas of intellectual property? Patent, trademark, copyright. And then there's a cousin, trade secrets, right? Like the secret recipe for KFC. That's trade secret. But the three, patent, trademark, copyright. When we're trying to protect our clients' intellectual property, there's typically one that's the primary protector, but then you have crossover. So for trademark, this is actually a great segue. Oh yeah, so and then I'll answer. Yeah, so I'm going to answer these last two questions as we segue to copyright. So as we look at it, the Starbucks mermaid, right? When that's used as a designator of source, when consumers see that and they know they can go find coffee, that's the trademark right in it. And the person or entity that's using that image in commerce owns the trademark rights by common law rights, and then would file to apply to register those. So Starbucks Inc., or whatever the name of the company is, when they were using that mermaid, they have the trademark rights. Now, that image is also artwork, right? And artwork is protectable by copyright law. So trademark protects brands. And so what we're protecting is the person or the thing, entity's rights in using this for people to realize they can get a certain specific product or service from them. That's the trademark piece of it. And that's owned by the user in commerce. Copyright protects the content. And copyright protects the creator, the author of this piece of content. So that mermaid has trademark rights in it. And also, too, the original illustrator of that design. It has nothing to do with whether or not consumers know they can get coffee from it. It has everything to do with the fact that that person drew this image. That is the copyright protectable right. So yes, if an image is used as a brand, it could be protected by trademark. And then also, too, the image itself is also protectable by copyright. So on a shirt, what protects an image? So that image on my shirt, it wouldn't protect the word guar, because short phrases and words are not protectable by copyright because they're not substantial enough. But the rest of that shirt is an illustration of the space aliens and whatnot going on. And so that image itself, the ornamental aspects of it, are protectable by copyright. Now, the difference between a trademark and a service mark is just that a trademark typically is the word used for a good. So so the coffee itself, like you roll into Starbucks and you buy a bag of coffee, Starbucks, as it's used on that thing of coffee because it's a good, that would be a truist, a purist, an attorney would say, oh, that's a trademark because it's used on the good. Starbucks, as it's used on the outside of the building for people to come and then get coffee as a service, right? Or let's say they provided a grinding service, right? You go in, they grind the beans for you. That's a service mark. So they're all sort of globally, people refer to everything as trademarks, but if you were to really hone in, If you're using it for the provision of services, then that's a service mark. And then if it's on a good, a product, then that's a trademark. And something to note too is if you are claiming your common law rights, so let's say you haven't registered your brand, but you've got a website up. If you're claiming rights and you're providing a service, oftentimes people might use a superscript or subscript SM, right? Stand for service mark. And you can use that. Also too, if it's a product, you might see a TM. And sometimes folks will just use a TM even if it's a service mark because they don't know the difference. Using a superscript or subscript TM or SM is fine if it's not registered to show you're claiming your common law rights. If you're using the encircled R, that little R encircled logo, I'm drawing it out for you here. That can only be used if you have a registration. If you use that and you don't have a federal registration or international registration, then that's fraud. And basically the use of that registrata symbol without a registration can be a basis for you to never protect your brand. The trademark office can deny your registration rights perpetually if you jump the gun and use that registrata symbol without a registration. So I advise against that for a number of reasons. Also, too, just so you know, if you are only going to offer your goods and services in Virginia and you never crossed state lines, there are state processes to register your brand just in the state. So you can register your trademark just in Virginia. But if you have the federal registration, though, you have protection here as well as the other 49 states in the union. Now, once again, copyright protects content. Copyright protects original works of authorship fixed in a tangible form. So as you're writing as you're writing your novella, as you're typing, right? As you're fixing the story in a tangible form, your rights are vesting. Naturally, your common law rights. As I'm pretty sure that everyone, if not 99.9% of us on this Zoom, probably have a pocket full of copyright protected works. Right? Anyone want to guess what our pocket full of copyright protected works is? Like, what are things that we all create on a daily basis and we keep in our pocket? Actually, I wasn't thinking text, but yeah, if it's a short phrase, maybe not. But yeah, if you're really writing messages, right? There's some long textures. If it would pass the substantiality test, and that's certainly text. That's not what I was thinking about, but that's a good one. What else though? Same idea though. In your phone, like what else do we all likely, if not every day, at least sometimes a week, create? And emails, yeah, that's right too. You're writing emails that could be copyright protectable.
Social media posts?
Yeah, that works. Yeah, social media posts, that could be text. But really, and this could be in text, social media posts or emails. But what I was going for is photographs, right? We all have cameras on us, and every time we take that photo, we've now created a new work. So original works of authorship fixed in a tangible form, and your rights vest in you upon creation. Now, the life of a copyright, once you've created it, if it's your own work, if you're the sole creator, the sole author of it, is going to be your life plus 70 years. Let's say that you're hanging out with a friend and the two of you decide, hey, let's write a song together. And you write a song and you capture it. Because remember, it's got to be fixed in a tangible form to be copyright protectable. So if the two of us got together and we just sang some songs, and we didn't record it. We didn't write it down. We didn't transcribe it. Arguably, there's no copyright rights because it never was fixed in a tangible form. So, so no rights would have vested at that moment. But if one of us pulled our phone out and we recorded it, and the two of us are sitting there, we're singing along, then we've really created two pieces of intellectual property. The two of us working together, we've created a song, right? This lyric and melody. And then also too, now we've recorded it. And so we both performed and we've created this recording. So we've created two pieces of intellectual property together jointly. We jointly own it, created it together. And so as joint authors of these two works, the song and the sound recording, the life of that copyright right is going to be the last surviving joint author's life plus 70 years. So, so as you folks can probably tell, I live a really hard life. So I don't know if I'm going to last past tomorrow. So let's say I'm gone, and my co-creator is just healthiest person ever. He probably has never drank coffee, won't even look at alcohol, doesn't even know how to spell sugar. Like that person's going to live for another 60, 70 years, which is great for the life of the copyright, because it's going to be, it doesn't matter that I'm dead. That person continues on living. When the co-writer dies, the co-author dies, it's going to be 70 years from that death. Now, when you create something, once again, you own it, unless a couple of situations exist. So one scenario would be if I create something as a W-2 employee in the course of my work or related to my work for my employer, then that nature of employee and employee-employer, my copyright would naturally transfer to my employer, and my employer would be deemed the author. That's a work for hire scenario. It's a W-2 employee in the course of your work. A relatively famous case surrounding this is the Ravens, and I forget which logo design it is, but there was someone on the custodial staff at the Ravens, and that person drew an image that eventually became one of the primary logos for the Ravens, and that person gave it to someone higher up in the organization. Was like, hey, check this out. What do you think about this logo? And they looked at it and said, oh, awesome. Thank you very much. They gave it to marketing and branding, and they ended up using it. Well, later that person said, hey, wait a second. You used my art. You used my, this copyright protectable work, and you haven't paid me. So you need to pay me a licensing fee. And they said, well, no. We don't have to pay you anything because you work for the Ravens. You're a W-2 employee, and we own that. And so the person lawyered up, and I personally agree with the decision. The decision was made that, well, yes, this person works for the Ravens, but as part of the custodial team, their job duties have nothing to do with drawing a logo for you. And so that did not automatically transfer. So you're going to need to pay damages and get this straight, right? So there's that employer-employee relationship, and it transfers if it's related to in the course of your work. Also, too, you may transfer your ownership by a written agreement. Now, one type of transfer is an assignment. So I've created something, and now I'm going to sell it and assign it to someone, and there's a written agreement. The other type of transfer would be a work for hire. And that's, let's say, and there's certain categories, and there's oftentimes arguments about what is in the category and what isn't. But for example, audio visual works clearly in the categories of work for hire. So let's say that I'm an editor. Someone hires me to edit their film, and they hand me a work for hire assignment agreement. Usually they bootstrap it in case for whatever reason the work for hire fails legally, that there's an assignment, but they say it's a work for hire. Well, because it falls within the category what can be deemed a work for hire, and there's a written agreement stating it's a work for hire, and I sign it, then that would transfer and could be deemed a work for hire. Now, something to note, if you are an artist, a creator, and someone pays you all of King Midas's gold, and you're not their W-2 employee, and they later say, hey, I own this, you can say, well, no, you don't own this. Like, oh yeah, like we said, it's a work for hire, I own this. It's like, yeah, about that, there's no written agreement. There can't be. There's no assignment, and it can't be a work for hire. Both have to be in writing. Now, maybe there's a license. Maybe you can argue there's a perpetual license, but as far as you owning this, that's not the case. And so if you're a creator, that's leverage if you need to get paid and someone hasn't paid you. All the money you're supposed to have, right, is, hey, you don't own it. Also, too, I'll have clients who oftentimes will say, yeah, I own it. And I'll say, do you now? And they'll say, yeah. And it's a work for hire. And it's like, what do you mean by that? Well, I hired them to do work. See, work for hire. It's like, I get what you're saying. I mean, but that's not within the legal definition of it. And so if you paid someone money and you're supposed to own it, make sure it's in writing, because that's, unless W-2 employee-employer relationship, there's no transfer of rights without a signed writing. That's a common mistake that we run up against with folks. Now, what rights do you have as the owner of a copyright? Right, you have the exclusive right to reproduce what you create. You have the exclusive right to create derivative works. You have the exclusive right to distribute copies, to publicly perform, publicly display. And this one's kind of specific, but perform sound recordings by digital audio transmission. Those are the rights that you have. And so if you own something, then realize those are your rights. Also, too, realize that if you're creating a derivative work of someone else's work, then you arguably would need a license, unless you're trying to argue that what you've done is transformative, and now you're relying on fair use. It's interesting what people will do, and this happens with some frequency in a town like Richmond, because we're fortunate to have organizations like CultureWorks and wonderful muralists and artists, and so what will happen is you'll have a muralist will paint a beautiful mural, right? And then what will come along is someone with an iPhone, or maybe they've got a Canon, or a photographer will come along and they'll take a picture of it, right? And then they'll start selling postcards of this mural. And in some cases, even the photographer will send out cease and desist letters telling people that they've stolen their image because they're using a photograph of a mural. And what's really funny about this is the photographer doesn't, I mean, unless they have a license from the muralist, just because it's on a wall outside doesn't mean that the artist has given you a license to take photographs of it and sell it for your uses, right? Most artists aren't going to go, attack you because you took a photo of it and you have for your personal use, right? It's out there. But it's funny. It's popped up a few times in my career where there'll be these disputes, and it's like, well, no, that's obviously a derivative. And in fact, honestly, if the photographer, if it's just a straight photo, it almost seems like an unauthorized just replica duplication, because they've done nothing to add their own creative spirit to the art itself, right? Now, and we're running out of time, 2 minutes. So just so you know, once again, copyright rights vest upon creation. You don't have to have a registration to have copyright rights. However, registrations are important for enforcement. In order to sue for copyright infringement, you have to have a registration. You cannot get in federal court without a registration certificate. Those, once you apply, it can take almost a year for it to register. unless you want to pay an $800 expedite fee. So if you have created something that you think is of significant value and you make sure that you can protect it, go ahead and register it sooner than later. Apply to register it sooner than later. Copyright.gov is where you go. Similar to trademarks, it's, I think, helpful to use an attorney, but you decide your own comfort level there. And also, too, if you've registered before the infringement or within this 90-day look-back period from first publication, then you can seek reimbursement of attorney's fees and statutory damages if someone steals from you. Those are off the table if you don't have a registration within either before or within that grace period. And oftentimes with IP infringement, it's difficult to assess damages. So you want to have statutory damages. So because that's gonna be what might get you an attorney to take the case. Because without that, you're probably, it's hard enough to find an attorney to take anything on contingency unless it's a personal injury claim. And even with a registration, it's still difficult. But without a registration, you could pay $60,000, $70,000, if not more, in federal court related fees to your attorney. And then you could even win, but then the judge, the decision maker, says, okay, well, you won, but the infringement was before you had a registration, so we can't give you statutory damages. And from what we can tell, maybe they cost you $1,000. So congratulations, Mr. Lauder, you win. Here's your $1,000. And then my attorney looks at me and says, hey, Justin, here's my invoice for 80 grand. So I'm $79,000 down, but at least to have the personal moral victory of knowing that I won. So I know we're out of time. I can stay for a few more minutes. I don't know what CultureWorks, what exactly how the format of this is, but yeah, I mean, we just really touched the surface, but thank you for spending your morning with me talking IP law. I'm gonna look at these comments here on the side. Yeah. So yeah, getting burned by a volunteer claim they owned content on the website. Yeah, that's a tough one. Unless there was a W-2 relationship or some written agreement assigning it, then arguably the person would own what they create. Now there would be a question of what was it just created anew, or was it based on something? What you had to parse it, but yeah, that is a difficult place to be in. So it's always best if someone's creating something for you or your organization to have these conversations sooner than later and put in place documents to ensure that you've got the transfer you need. Yeah, as far as the timing of filing, I've actually never done it. There are some pre-registration options, but I think it's specific to types of work. Typically, and actually, let me think about this. So before you publish something, you can file the unpublished works. So let's say you're working on your novel and you're halfway done and you want to go ahead and put some protection around it. In theory, you could file to register this first section, and then later when it's complete, you could file for the second section. And what you would do is you'd file for the whole thing, then you disclaim rights in the first half. So yeah, I think it just depends on what the nature is of what you're creating, how long it will create, and deciding if there's a good stopping point or not. Yeah, that's a fascinating question. Typically what folks will do is, if they're trying to limit risk, mitigate risk, is they'll apply to register before they publish. So before they start distributing copies for further distribution, that's when they'd apply. Something to note is that by registering it, you're giving a copy of the work to the federal government, right? So the idea is that they're going to give you bolstered rights and a limited time monopoly for you putting it on file with them. So then later, they have it for future generations. So, um, reading the last piece here.
Okay.
I have a contract assigning certain rights to an org, but the contract doesn't state that copyright reigns with me. Yeah. What I would say to that is, please feel free to contact me, and we can talk about that specifically. I don't want to probably giving anything that could be deemed legal advice in a public area. That it's probably risky for everyone, just because one, anything said can't be deemed attorney-client privileged, and it's just probably not the right setting for that. But yeah, I'd look to the contract to see what it says. So generally speaking, is what does it say on its face? And the Copyright Act is written in such a way that anything that isn't expressly given is implicitly reserved. So the law was drafted in such a way to help protect creatives. But yeah, we just need to dig into this specific language. So, oh, you're welcome. Any other questions while we're here, wrapping up?
I've got one, Justin, like, for example, if because I do a lot of photo video work as well, and on occasion that has popped up where somebody has used an image without permission somewhere else. What if you do find that somebody's using your work in that way? What's the best way to go about approaching that? Is it best to directly contact those individuals and explain that it's not theirs and ask them to take it down, or go elsewhere first?
Yeah. So reasonable minds may differ as to the approach, but it boils down to the people involved, right? And so part of it is your demeanor and the way that the client feels it should be handled, but also too, it's partially what do we know about the infringer and that entity, right? Does that entity have a reputation for taking certain actions, or being a bad actor, or being belligerent, or it could be an entity or a person? So I have had instances where a client will talk about it, and we'll say, okay, well, in this instance, this is a Target, right? And so for Target, not that Target has done anything specifically that we think they're belligerent, but Target's a pretty big company, and in order for us to get their attention, probably we should have an attorney send that letter, because if it's just someone saying that they have rights in it, likely go ignored, right? So in those instances, if it's a company, then likely an attorney is a good place to start. If it's an individual, and especially if it's an individual in the community that you know or have some relationship with them, or at least know of them, then sometimes reaching out personally and just trying to engage at a lower levels could be helpful, because then you can escalate if they ignore you or there's no progress. Sometimes if you come out of the gate too hot, then depending on how that person reacts, it could cause more friction. Whereas just reaching out and saying something might have been, oh, sorry about that. We'll just take care of it, right? I'll take it down. So it's fact specific, but I've done it both ways. So.
Well, and kind of a follow-up question to something you kind of already addressed, but that issue about taking a picture of a mural, for example. You see a lot of people, you go to the VMFA, people are taking pictures of, work in the museum. But how does that work as far as social media? You're walking down the street, you take a picture of a mural and you tag the artist and put it up on social media. Where does that fall in that usage?
Yeah, it's sort of like everybody's doing it. So is it, would it constitute a fair use? So it's a I think, 7-factor test as to whether something's fair use. And I would have to look to see if anything's been litigated on this. But if you're out at an event and you take photo of something and it's other stuff in the photo, or even if it's just the main thing, and let's say you post it on Instagram, right? That likely is an infringing use if it's just the work and you post it on Instagram. But then the question is, well, what are the damages, right? How have you harmed the artist, and what is the artist really going to file a lawsuit against you in federal court, right? Now, what's more likely to happen is it's highly unlikely to be an issue. But I will say, and I'm a human being, and I definitely have taken pictures of stuff out in the wild and posted it. Especially because of my knowledge and my day job, I try not to, I certainly don't take photos of people's work and sell it, right? But if you go on my Instagram, you will see murals in the background of things, right? But so generally speaking, I think that risk is relatively low in those instances. But here's a real life example. And if you Google it, you'll find this person, because there are copyright trolls. So there's a copyright troll named Linda Ellis, and she wrote a poem called "The Dash." And it's not about your birth date, it's not about your death date, it's about how you live your dash, right, on your tombstone. And so it's this poem about the dash, and I'm not sure if Miss Ellis is still alive or not, but essentially, Miss Ellis has a guy named John. I don't know if John still works for Miss Ellis, but they just look on the internet, and I've had at least a couple clients over the years that have come to me. Well, actually, I had a client, then had a friend who had a client, so not my clients. But basically, what's popped up is they'll hire like a marketer to help them market their fitness gym or whatever they're doing. And so the third party contractor will think, oh, this is a cool idea. Like, I love this poem. I'm going to post this on Facebook. It's like Inspirational Monday. Let's go get life. And then it'll be about live dash, right? And they'll post the poem. Well, what they do is they scour the internet and see when people posted the poem. And then they send them a cease and desist letter, an Instagram. And it says, look, here are screenshots on Inspirational Monday. You posted our client's poem in its entirety, and we typically license this out for this much money, and it's registered. And if you've registered your copyright protectable work, then per infringement, you can seek $750 to $35,000, and if you can prove willfulness, up to $150,000 per infringement. And so basically, they'll say, look, we've got all the proof here. Obviously, it's you. There's the poem. It's registered. Because you knew who we were, you attribute it to our client. We think it's willful, so we're probably going to sue you for 150 grand. So you can pay us this much money, and we'll make this go away, right? And so then there's a question of, well, how do you just ignore them? Do they file what we believe to be a frivolous lawsuit? Although we did use it, and there does seem to be some legitimacy, even though most people would think it's bogus. That's why they're called copyright trolls. And so, if you just Google copyright trolls, and there's patent trolls as well, but copyright trolls, Linda Ellis, you'll see all sorts of history. So the advice that I could give is, if you are posting things, if you're in a museum and you're posting something that's 1,000 years old, and that's in the public domain, right? It's no longer copyright protectable. So you're fine there. Like posting a Greco, right? Velasquez. If you're posting Dali, I'm pretty sure that and I have to look and see what Spanish copyright rights are, but under the Berne Convention, I'd say that probably Dali is still copyright protectable. Given when he died. So yeah, ephemeral social media posts, likely not a big issue, but be respectful of the artist. Taking photos and then selling postcards and posters and T-shirts using someone else's artwork. In my opinion, my thought is that's just downright theft. Now, if you happen to make a collage of a bunch of different images and you know you've changed them and you can argue that it's transformative, perhaps you can argue it's fair use. But fair use is a defense. It's not a silver bullet. If you're arguing fair use, it's because someone is sending you letters or has already sued you. So. I'm not sure if I answered your question, Daniel, but I did get to say a lot there. So thank you for the prompt.
No, I think that answers the question. Thank you. It also kind of reminds me of there was a photographer some years ago. I read an article and I'm blanking on his name. The guitarist for Queen played a concert and a photographer took pictures of him on stage, and he then shared a picture this photographer took of him on stage, and the photographer, she sued him for some large amount of money because he used the image she took, thinking it was okay because he was in the picture, but it was still, a work produced by the other photographer that he did not have right to reuse, even though it was his face. Kind of a funny story.
Yeah, it's interesting about that too. Is then you have there's a right of publicity, right? Because Brian May, if it's so, depending on how the photographer was using it too, Brian May might have countersued, right? That but the photographer did not have right to use his name, likeness, and image in a commercial use. So yeah, the copyright piece of it, the photographer would have rights in the photo, but then there could have been the other shoe being Brian May's rights of right of publicity. And we run into that with Guar, in that not right of publicity, but if you're familiar with the band, they're artists that create elaborate costumes and set designs. And so there are photos of them. It's essentially taking the photo of someone's mural, right? It's taking photo of someone else's work. So it's a derivative work because we've got copyright rights in what we've created. And so in order to take those photos, you would need a license. And so we've had issues with photographers before. And I just say, if you're going to push on somebody, make sure that you understand, make sure you know whether or not you're in the wrong, because you could kick a hornet's nest if you send a cease and desist letter to someone that you needed something from, right? So like if you took a photo of someone's mural and then you sent a letter to the muralist telling them that they're infringing you because they used your photo, which your photo is just a picture of their mural, and let's say the muralist has registered their mural and you haven't registered your photo, then that's a great place for the muralist, because I'd write back and say, thank you for alerting us to your infringement. We've got a registration, and obviously my name's in the bottom corner of it, and I've looked at your website now. It looks like you've got at least 20 other images of my murals that have all been registered. So I see that you haven't registered your one photo that I use. So okay, so you're not registered. Likely, you sell your prints. So your website says that you give a license to use it for $100. So I don't agree with you that I owe you $100, but let's just say that you had your $100. So here's your $100, and now I've got at least 20 photographs that you're selling to people of my art that are all registered, and I believe it's willful. So $150,000 times 20. You do the math. So how about you deduct $100 from that? Because I'm going to be a nice person. You just keep your $100 and you pay me the rest of that money, and we'll call it settled. Or you can sit down and get ready to be sued because you sent the letter to the wrong person. Not trying to be overly aggressive, but it can be sometimes offensive, the way that someone might value their property over someone else's, and then send the person that they're stealing from a letter that's pretty nasty. So, and I've had that happen over the years a few times, and I wouldn't say I rejoice in it, but usually I was like, oh, okay, yeah, you're about to learn something.
We don't have any more questions in the chat, so thank you, Justin, for being our guest presenter this morning. And he did leave his email in the chat if anyone needs to contact him outside of this. And I would like to thank everyone for joining us. This will be a monthly series, and our next presenter next month will talk on funding strategies, and look out for the registration notifications that will be coming in April on our social media. Thank you, everyone, for joining us.
Thank you all so much for having me. Great to
Bye.
take care.
Thanks.